2014 AP1 001 9802 East 79th Street, Lawrence Township, Council District 5, 1.58 acres, zone C3. Robert M. Middle is requesting appeal of the administrator's decision to issue a sign permit number SGN 13-01214 for a 378 square foot, 40-foot tall tri-vision billboard. All persons speaking on this today, please step forward and be sworn in. Raise your right hands, please. Do solemnly swear or affirm under the penalty for perjury to tell the truth, the whole truth, and nothing but the truth? Petitioner, state your name and address for record, please.
Good afternoon, members of the board. For the record, my name is Mary Soliday. I'm attorney with 2700 Market Tower. I'm representing a number of citizens. As a matter of fact, over 1,000 people have signed a petition in support of this matter today, loosely labeled the Guys Billboard Appeal Committee. I would like anyone here who supports our position that this sign was incorrectly permitted, that the permit was issued in error, to please stand up. Thank you. Members of the board, this permit for a board that is shown in your packet was issued on December 18th. It's a tri-vision billboard. The property in question, as I'm sure you know, is at the northeast corner of 79th and Fall Creek Road. We're putting up on the easel pictures of the sign in question. Members of the board, frankly, when this sign went up, I can't tell you the amount of disbelief that area residents and elected officials had that the city would permit this sign. In essence, we believe not only is it objectionable aesthetically, but we also think it's unsafe, and we think that's a rationale for you to revoke the permit. We also think there are some arguments under the ordinance, and we'll get to in a few minutes, that the ordinance was improperly interpreted by staff. Members of the board, regardless of what you hear from the billboard permit holder, you have the authority to decide whether this permit was lawfully issued or not. You have that authority under local ordinance and under Indiana code, so this is your decision. Members of the board, also, before we get into more of our technical arguments, want to point out not only do we have all these fine people who've taken their time to be here today, we have letters of support from State Senator James Merritt. We have the Mayor of Lawrence, which is across the street, is the corporate boundaries of Lawrence, opposes, and Councilor Jeannie Kane has been kind enough to join us today. She intends to speak, which will not be counted against our time, as I understand it, based on your practice. Okay, what are what I'm going to call the reasons you have to lawfully revoke this permit? What are they? Well, the first one relates to, and this is set out in your packet, members of the board, tab 4, sign regulations. Section 734-100 states that the purpose of the regulations is to eliminate potential hazards to motorists. Section 2.02 prohibits signs which interfere with or obstruct the view of or can be confused with any official traffic signal or device. The Tri-Vision's own marketing material says that the board is impactful and attracts even more attention to the message. As you know, this intersection is very busy. There are many signs, there are multiple lanes. It's a little bit of a confusing intersection, to say the least. And I don't think there's any factual disagreement that there is a conflict, particularly when you look at the pictures in our packet, again, tab 4, that this sign interferes with the visibility of a traffic signal. So therefore, again, under the sign regulations, section 734-100, this permit should have been denied. Members of the board, there is also, I believe, a very strong legal argument that the measurement was improperly conducted, with all good intention, but improperly conducted by staff. That is because when you look at the history of this area and how other permits were issued, they were all based off the center line of Fall Creek Road, not the western right-of-way. And that relates to the original 1995 rezoning of the subject site. It relates to these zoning of the Oak Haven and Ridgewood Hills subdivisions, which again, when those permits were issued, were based off the center line of Fall Creek Road, and more significantly, under Municipal Code Section 730101, the measurement is required to be from the center line. In this case, the measurement was done by staff based on the western edge of right-of-way. Why does that matter? Well, it matters because the zoning ordinance is clear. There has to be a 300-foot separation between a protected district, which is a residential district by definition, and the sign itself. So we have, in essence, based on this proper measurement, the sign is 20 feet in violation of that setback, meaning that it's 20 feet too close. And I'm not sure that it can be moved to make it in a proper place, based on this interpretation of the ordinance, which again is supported by municipal code. Thirdly, there have been a number of cases, at least two, and probably others, that have been heavily negotiated between neighbors, neighborhood associations, staff, and petitioners, going back as far back as 1982, when the C3 district was zoned, that required a, quote, uniform architectural styling and character with uniform signage. And I say this because I believe it's been the MDC and hence BZA established policy as to this property that a billboard, certainly, I don't think anybody could without being a little bit off base, say that a billboard that looks like this is of uniform architectural styling and character with uniform signage. The signage that's in the area with the CVS and the other small shops, small mom and pop businesses are uniform in character, and this really doesn't meet that commitment. You also have CVS, which in 2005 was able to essentially through a long series of negotiations, negotiate with the neighborhood association and staff a electronic variable message center sign, which interestingly was never erected, which I think speaks volumes to the fact that CVS, on whose land is located, thinks that even an EVMS sign is inappropriate. But regardless, at that time, 2005, CVS decided they wanted one. Long series of negotiations and commitments that basically said that, again, this concept that signage has to be uniform, it has to be in keeping with the character of the area, and clearly, again, that's not the case. So, in essence, we think that this is an interpretive question for you members of the board to decide. You have the authority to decide this. So with having said then sort of what I'm going to call legal arguments, we think there's also a number of policy arguments. I'm going to turn it over to Randy Frisk, who has led this group and has some comments and some handouts for your attention. So thank you.
Good afternoon, ladies and gentlemen. My name is Randy Frisk. I'm an 18-year resident of this area, along with my constituents who you saw here. We're talking about this sign. And much like the Colts lore sneaking out of the dead of night, this thing popped up all of a sudden, and everybody said, how did that happen? How upset were they? Well, in a short period of time, over 1,000 residents signed a petition to support this petition to revoke this permit. That included over 280 comments, with comments such as a jarring contradiction to the environment, dangerous to drivers. I can see it from my window. It cheapens the look of the area. And CVS, note that it's less than 60 feet, you can't see it on this picture, but less than 60 feet from this sign, logged a record number of complaints, according to conversations with their customer care line. In addition to that, as Ms. Holliday noted, we have Lawrence Mayor Dean Jessup and Senator Jim Merritt that have opposed this as well. So basically, what's wrong with this sign, in addition to what you just heard? It's a huge off-site advertising billboard that is completely out of sync with the surrounding, otherwise charming and well-manicured neighborhood shops and stores. And secondly, it's a danger to traffic in this area, specifically the eastbound lane of 82nd Street. Now, this property was originally rezoned C3. If you look at tab A of the documents you just got, This area was originally rezoned in 1982 to be a C3 property, to provide services to and for the benefit of the residents, not a sign owner. And the images found in that tab show what the area is supposed to look like. Locally owned mom and pop shops, rolling hills, rural landscape, and winding streets. And this billboard destroys that aesthetic. Now, if you look at the next poster here, you should have this, I think, in tab 1 of the original packet that you got. You'll see the top section again, what it's supposed to look like with tasteful structure and grass, and then the middle one with the billboard. So, what are we going to see in the years coming when property values drop? And mind you, there is a correlation between billboards and economically depressed property values. That's in tab C of what you've been given. So what's to happen in the future? Likely the bottom one, which maybe you can't see too well there, but in the packet you have gun shops, dilapidated buildings, lowering property values, and significantly a lowering tax base. The sign regulations of Indianapolis and Marion County in Chapter 734 recites the purpose of sign regulations to include encouraging signs which are integrated with and harmonious to the buildings and sites they occupy, to retain current residents, and to safeguard and enhance property values. Well, this sign not only does not do any of those, but it is 180 degrees opposite that. Also important, only 5 other billboards have been approved in the last 10 years for C3 properties. And you have that at tab 4 of the packet handed to you. What's significant there is that the other 5 are on intensely commercial corridors. Meridian Street, Raceway Road, North Michigan, Pendleton Pike, and South Emerson. You can see those are completely different in stark contrast to the current site at 79th and Fall Creek. But perhaps more important and more of a concern to the residents is that in each of those, for as far as the eye can see, you can see the billboard, it's flat. Also, the roads there are straight, and they don't have a curve dumping into an intersection, which has been labeled substandard by a 2011 scoping report, which is tab D in your packet, which found that stretch of 82nd Street to be substandard, having a 14.5-degree grade and a horizontal curve and a 40-mile-an-hour approaching speed limit. So, what are we talking about here? This is extremely important. When you're coming down 82nd Street toward Fall Creek, the top picture, you see the surrounding foliage, the trees. Then you come down, all of a sudden you're in an intersection. What do you see? You see this billboard, this huge billboard that has tri-vision with panels that rotate. And the advertising for that on tab 4 of your original packet says that that is specifically to better attract the attention of people looking at it. So you're down there, you're coming down the intersection, all of a sudden your attention is grabbed, and all of a sudden you find yourself in the middle of this intersection. So the question I ask is, how many cars with a child seat in the back need to be T-boned from the side of somebody with right-of-way because they were distracted by this sign? Thank you.
Near the Billboard intersection for 25 years. And I have a relative who lived in the area for 70 years in the hill overlooking this intersection, and we all cherish the beautiful nature of the valley. And just as my family and I have had our lives enriched by this beautiful area, I want current and future generations to have the same privilege. Here are some comments that fellow residents have made about the billboard. A sign of this size belongs in an area like Castleton, with mostly business traffic. Most of the heavy traffic at this intersection is residential. There are 2 small strip malls near the billboard. The billboard detracts from signage of local businesses in both of these strip malls. We need to support our local businesses and not make it harder for people to find them. A realtor posted this comment: I know the billboard will not bode well upon those looking to purchase homes in the area. The billboard makes the area feel like a shady area. Another petitioner wrote, while driving east on 82nd Street, I have caught my eye glancing at the billboard versus paying attention to the stopped cars And finally, this intersection is the main route to high school for many local neighborhoods. High school students are less experienced drivers, and for everyone's safety, we do not need to have them glancing up at a turning billboard. This petitioner wrote, "I feel like my life is at risk now every time I head through that intersection." Thank you.
Thank you. Since time is short, let me just try to summarize, which is, first of all, my view is that Indiana code clearly supports the notion that your most important responsibility as a board is to protect public safety. I think you've heard a lot of testimony about grave concerns about that. Secondly, we understand, I know your council will tell you, that you are required to find findings of fact, 4 findings of fact that we're handing out now, that to support your decision today, should you choose to do so, and we hope so, to revoke this permit. So we have drafted those findings of fact, we'll show them to your legal counsel, but essentially they touch on the things that I'm going to say one more time, which that first of all, I'm out of time, so I'll say that time for rebuttal. Thank you very much.
Thank you. We're going to hear from the
This is Councilor Ginny Kane, I'm sorry. We have 2 city councilors.
I think you come out from the remonstrator, according to my instructions. Okay, we'll hear from the remonstrator. You have 15 minutes. Remonstrator. Is that the staff?
Chairperson Pat, members of the board. I'm Mike Quinn, attorney with offices at 320 North Main Street here in Indianapolis.
Mr. Quinn, did I swear you in?
Yes, you did.
Okay.
The only reason I'm hesitant to come up here because I'm not really remonstrating, because I'm here as counsel for Mr. Lee, the permittee of the sign. Coincidentally, I've lived on Geist Reservoir for over 30 years. 32 plus years. That being said, my client informed me about a week ago that he and Mr. Frick had a conversation. Mr. Frick had informed him the case today would be continued, and so I'm not prepared to make a presentation since I was informed by Ms. Saladay, counsel for the petitioner or petitioners, that the case was going forward today. I didn't want to ask for continuance. I immediately called my client, and he said he could not be here and for me to go ahead and represent him as best I could. That said, and Mr. Smoker will certainly represent the city's stance on this particular petition, I would like to say on behalf of my client that my client has done everything that we're aware of that he needed to do to obtain the permit, and he did not tell any lies or mistruths or misstatements, if you will, in terms of obtaining this permit. Driving through that intersection every day, because I go through that intersection going to my office, which is here in downtown Indianapolis, and my home, I go through that intersection at least twice a day, sometimes 4 to 6 times a day. I didn't even know the sign was there until Mr. Lee called about 2 weeks after the sign was up. So it shows you how short I am, and I apologize to everyone here. And I happen to have been the misfortune of being the attorney both on the rezoning of the southwest corner of 79th and Fall Creek, as well as the Kroger store, and as well as the EVNS sign that Mrs. Saladay referred to. That being said, I would defer to Mr. Smoker in any questions he may have. Again, I am not prepared to make a presentation on behalf of Mr. Lee, and I would like the board to know that. Thank you.
So I guess we'll hear from Mr. Smoker. This is just for the audience to know, we don't usually have cases like this. This is an unusual one for us, and so I guess I need to know whether the city is limited to, in our remonstrance, our 15 minutes. Is Mr. Smoker under that 15 minutes?
No, he's not.
So you're not, so we will go straight to council. We're done with remonstrance, we'll go to council, and and then have staff. This is really new for me, who is who in this room. Yeah, so, yes, so let's hear from the city council.
Thank you very much. Good afternoon, my name is Jenny Kane, and I am the City County Council for District 5, where this billboard is located. This is the second time in 10.5 years that I have spoken to the Board of Zoning Appeals on a subject in my district. That is how important this appeal is to me and my constituents. What is important to us? Number one, the setting. I have been known to tell people who cannot make it to Brown County in the fall to go drive Fall Creek or Sargent Road for the same effect. The hilly terrain, woods, Fall Creek Valley, Mud Creek, the animals you will see, the natural settings are all gems to enjoy and preserve. The uniqueness of this area has been recognized in the comprehensive plan for Indianapolis. The comprehensive plan labeled the area around the billboard a critical area because of the Fall Creek Valley, woods, a heron rookery, protected well fields, and hilly terrain. Therefore, a huge tri-vision billboard does not fit the aesthetics and natural beauty of this area for the people who live there, drive there, and have contributed to the comprehensive plan. Secondly, when going east on 82nd Street to Fall Creek, there is a winding hill going down into the intersection of Fall Creek and 82nd. When you get to the bottom of the hill, the stoplight falls directly in the middle of this billboard that is changing for the driver's sightline. It is very distracting, and I believe this is a safety hazard for this already tricky intersection. Third, I have watched scores of my neighbors from my district react to this billboard. What can we do? Well, what we can do is what we're doing today, this appeal. I have watched them email me and city officials. They have set up a Facebook to communicate to each other. Over 100 people came to our first town hall meeting on this. Money was raised for the appeal in less than 3 minutes. They formed a committee that has met weekly to research and organize. We've gotten over 1,000 signatures for the petition. Hundreds of flyers have been passed out, and money has been raised for legal representation. The commitment of time, talent, and money by these many neighbors to stand up against this particular billboard because of the reasons I have stated is very admirable to me. I am so proud of each one of them, and I hope you see that this is important to all of us. We want to protect and preserve the natural beauty of this unique area of Marion County that we call home. Thank you for your consideration. I also want to mention that City County Councilor Michael McQuillan has written a letter that can go into your record. And I'd also like to invite Councilor Steve Talley, who's come today, to also speak on this. Thank you.
Thank you very much, Madam Chairwoman and members of the commission. I'm the counselor for District 11, located just immediately west of the sign referenced in this petition. As council members elected to represent the citizens of Indianapolis, we have a responsibility to provide a safe and healthy environment to raise and educate our children. And a major component of meeting that responsibility is by encouraging home ownership and standing firm against business attempting to encroach into residential areas. And this billboard, and a billboard such as this one near the entryway into a residential community, does in reality constitute a business encroachment and does not encourage home ownership. It is my belief this business encroachment into a residential neighborhood can have a negative impact on property values. And as councilors that represent the neighborhood with a shared boundary, I ask that this commission consider the interests and the comments that you've heard today from our Lawrence Township residents, and thank you for your consideration.
Thank you. Are there any questions of the councilors? Okay, let's hear from staff.
Thank you, Chairperson Taft, members of the board. As you noted, this is not a common case that comes before this board. In terms of addressing who is who, we have the first part is file the petitions, so there are the petitioners, and then the owner of the billboard, represented by Mr. Carter, who would be your demonstrators. So staff remains technical expertise to petition before you. When we look into an appeal of a permit that was issued, we ultimately do a thorough review of all the technical aspects that go into that permit. Is the zoning correct? Does it meet the setbacks, height limitations, area limitations, and all the things that are reviewed when a permit is issued? Had one of those been out of line with those zoning standards, then it would have been issued in error. But when staff reviewed all those aspects, it was clear that they checked the boxes, and then ultimately the permit was issued based on those standards and the board meeting that standard. After the board was erected, it's clear that it meets what the permit allowed, what the zoning district allowed, and what the Vermont standard had filed to build that billboard. And so staff did not find any technical aspect in which the billboard should not have been issued a permit. You certainly heard a lot of testimony about the impact of large advertising signs in the C3 district. It is certainly true that the C3 district is a neighborhood service district more than a heavy commercial district. That is a much broader discussion, perhaps, than the specific site at the specific time, given that our focus is whether or not this permit was issued based off of meeting all the specifications to issue a sign permit for a billboard. I included the tables where those technicalities come from in the back of the report. Would happy to discuss any of those with you or answer any questions. But at this time, I'm happy to answer any questions.
Are there any questions for staff?
My question relates to the findings of fact we were handed, number 4, which talks about the measurement off the center line versus the right of way. Do you have any comments on that?
Yes. The reference to a zoning boundary in a city line has to do with freeways that run through Marion County. When those were originally established, they were not zoned for any land use. And so when that was noticed, then the law came into effect that a zoning boundary along a freeway goes to this freeway at the center line of the freeway. So this not being a freeway, it would just be to the district boundary where it lies.
Are there any other questions of staff? Okay, let's now hear from our petitioner.
Thank you, members of the board. Again, with all respect to staff, they typically do a very terrific job. I just think they've missed two significant ordinance interpretations in issuing this permit. Let me repeat again what they are. We do not think the staff considered the section 734-100 of the sign regulations. And if you look at the findings of fact we handed out, that section specifically indicates that the purpose of the regulations is to eliminate potential hazards to motorists. And that section specifically prohibits signs which interfere with or can be confused with any official traffic signal. I mean, that's our case. And we just think the staff didn't consider that section. Secondly, and I think as significant, again with all respect to staff, is this measurement issue. If you go to finding number 4, this off-center placement, that is measuring from the edge of right-of-way as opposed to the center line, is wholly inconsistent with how they've done measurements for every other permit in the area. So we don't quite get that. We just don't agree with that interpretation. That's maybe the best way to say it. We do not agree with that interpretation. We think there's a legal basis based on this point, and again, section 734-100 for you to revoke this permit. Again, under Indiana law, under the local ordinance, you have the legal ability to do that. And with all respect to everybody else involved here, we appreciate everybody's civility, by the way, appreciate the audience containing their emotions very well on this, because this is a hotbed of emotion, understandably. We beg you to apply what we think are the two bases to overturn this permit. Let the chips fall where they may when that happens, but again, you have the lawful ability to do that. Happy to answer any questions. Thank you very much.
Are you saying that in this case, you believe the standard of measurement was different than what was used in other projects in that area?
Yes. Including, bear with me one second, I want to get the subdivision name correct. The Oak Haven and Ridgewood Hill subdivisions, when they were zoned, the measurement was from the actual center line of Fall Creek.
Okay, thank you. Are there any other questions of the petitioner? Let's now hear from the demonstrator.
Thank you, Madam Chairman, members of the board. I guess I'm the lone demonstrator. I guess you could consider me around demonstrator since I represent Mr. Lee, the permittee. I would suggest, since really the question that has been broached to you by virtue of this application and the presentation made so ably by Ms. Saladay, that you should defer to Mr. Steinmetz, your attorney, to see if there is a legal question that would give you grounds to grant the revocation of this permit. Secondly, I would like to say that I certainly don't know about the standard of measurements in terms of whether this was appropriately followed or not, and I would certainly defer to Ms. Saladay about that issue in and of itself. Suffice it to say, I'm not prepared to make a rebuttal. I may make a presentation, as I told you before, because my client told me that he was told by Mr. Frick that this case would be continued today, and I was just over here to testify as to the continuance if any need was made of me for that particular request. That said, I would think that knowing full well how the Department of Permits works and the Department of Code Enforcement works in terms of issuing permits, especially billboard permits, that they were very careful about granting the permit for the sign for this location. Lastly, I would like to say, just personally, that I've heard several concerns about this intersection, and having driven this intersection for at least 15 years, probably longer, but at least I can think of 15 years, I've never seen a wreck at that intersection, and having, I know
I saw a motorcycle get killed at that intersection.
the people that are laughing at it certainly have a right to do that, I guess, if they want to be inappropriate for such a hearing as this. Suffice it to say that the record speaks for itself, and I said I have personally never seen a wreck there at that intersection. And again, that's me personally. That's not to say that a wreck hasn't occurred at that intersection. That said, I would ask you to see that this petition for approval or rejection of this permit, if you will, should not be granted, and I would refer to Mr. Steinmetz and to Mr. Smoker as to if there's any violation in terms of the way this permit was granted. Thank you very much.
Are there any questions of the demonstrator? I would like the attorney to instruct us on the voting, just to make sure we're clear on this. And then if you could also, I think you explained to me which vote would take it to NBC, and if you could kind of explain what happens from here depending on how we vote.
Very good. As an initial matter,
Actually, I guess I forgot to invite our counselors to speak again. I'm sorry. If you would, our city county counselors could speak again. No? Okay, all right. Back to the attorney.
Counsel for the petitioner indicated that I had been provided with copies of findings of fact. I had not. So regardless of how the vote goes today, it will need to be continued for adoption, either findings of fact in support or negative findings of fact. As everybody's noted, this is an unusual situation. Normally, where you would have an appeal of an administrator's decision on a sign permit, it's going to be the person who was denied the ability to erect the sign. In this case, it's the neighborhood group that is objecting to the issuance of the permit. They're the petitioner. The burden is with them to demonstrate that this permit was not lawfully issued. That's their burden to demonstrate. As far as an appeal from this board, there are different appeal options depending on the party. For instance, the administrator has the ability to appeal this to the NBC, and that's kind of the end of the road for it there. If the petitioner or demonstrator appeals your decision, then it has the ability to be heard by Marion County Superior Court under a judicial review.
So, as we vote, are there any other questions? Or I just want to make sure you understand how we're voting.
I don't think I understood.
Okay,
So
so,
that was not clear in terms of the role of this board.
Okay, a vote to approve this petition would revoke the sign permit and deem it issued improperly. A vote against the permit says that the permit was properly issued and the sign shall be allowed to stay.
so just because this is kind of, this again is a different case for us, and so we're kind of going to take it backwards in a sense. So if we vote, if we approve the petition, we are voting with the petitioners and removing the permit for the sign. If we vote against the petition, we are voting against, to uphold the permit. So everyone is clear. Are there any other questions before we vote?
I have a question, attorney. So, you've got these findings of fact now?
I did, but I've not had an opportunity to review them.
Okay, but let me just pose this for you without looking at that then. So if we believe that this, for example, does interfere with the stoplight, which, you know, is right in front of the sign as you come down the hill, that would be a basis for us to.
So, what we're trying to figure out, that's what I'm doing now. Okay. So, what we're trying to figure out is whether we can we only determine if the permit was properly issued, or can we determine, often when we look at cases, we can look at topography, we can look at what the aesthetics, we can look at how it affects the community. Are we allowed to look at that today? Or are we only allowed to look, can we say, and I don't know how people will vote, so I'm just.
Can I answer my question?
I'm sorry. Okay.
My question was that if we believe that under the sign regulation, that this does interfere with the traffic light, can we, on the basis of that determination, our determination of that, can we vote to uphold the petitioner or not, like that? Or do we have that kind of judgment available to properly look at this?
The section of the ordinance that has been cited along, that would be 734-100, is a statement of the purpose of the ordinance. And so that is one of the purposes set forth for the reason why the city chooses to regulate signs. Okay? Does that answer your question?
No, and then my question, and I understand that, so if it's our decision, whether or not they took this into account or not, can we do that? That's what I'm asking. What is the basis of our overturning this?
Your basis is solely on the record of what's been presented to you here today, okay? So, there was various testimony from different folks. As the board, it's your task to sort through that and determine, the validity, the force, and that sort of thing of the testimony that you heard.
And Council, I just make one clarification, if I might be allowed. Section 734-202, which is recited in finding number 1, is the specific ordinance section that specifically prohibits signs which interfere with any official traffic signal. So that, I think, with all respect to everybody else's view, my view is that gives you the legal foundation to revoke the permit. Thank you.
Since the bishop spoke, I need to let that demonstrator speak.
I believe since Ms. Saturday spoke with you, I must also say that in my view as a lawyer, that the only issue before this board, and it takes 3 out of 4 of you to come to a decision one way or the other, since they're on board and present by the rules of the Board of Zoning Appeals. But the only issue is whether the permit was properly issued. If it was not properly issued, you may revoke. And you may certainly defer to your Mr. Steinmetz as your counsel to agree or disagree or editorialize.
So I think the part of the question is whether or not the board feels that the staff reviewed the purpose of the sign ordinance and should have issued the permit based on the purpose.
Chairperson Pat, if I may, those purpose statements are ultimately what establishes the rest of that section of the ordinance. And so the thought being, those are what go into making the standards for the districts and the sign height and all of those regulations. So that one, in terms of the standard that she's referencing, it's not a specific standard that's pulled out and applied to each sign permit. It is what establishes and creates all those districts, so you know how to apply those ordinance standards to a permit. It's certainly factored into the decision on issuing a permit, but that's where those technical specifications in terms of setback and size are regulated from, is to try and meet those purpose statements.
And when the staff person is reviewing it, are they looking at findings of fact?
For a permit, they would not be. It's just,
So why, if they aren't, why do we have findings of fact?
well, that is for the board to consider. But when they issue a permit, it is based off the technical specifications of the ordinance. So it's basically a checkbox, and if you meet the checkboxes, then it's issued.
Are there any other questions for staff?
I have a question. In the staff report with the paragraph discussing lighting of the outdoor advertising, is this anticipated in the future for the sun?
I'm sorry, you say anticipated to be in the future?
Is the sign to be lit?
I believe it is illuminated. I think there's 3 or 4 lights on either side that are generally orientated towards the sign, back towards the sign. So almost uplighting, but angled towards the sign.
May I address that, the answer to that, since you did?
To answer the question.
Our understanding and research is that there are 400 watt lights on that sign, and they're largely off right now. We suspect they're waiting to find out what happens here, then they'll go on. And we've also learned that there is no limit in the regulations to how bright that can be.
Are there any more questions? So we will now vote on 2014 AP 100.
AP 1001, 4 votes cast. Ellingson voted yes. Clark voted yes. Hatch voted yes. Taft voted yes. 4 yes,